So the official term for an eviction case in Alaska is actually called a forcible entry and detainer. The eviction process can kind of differ from county to county, but more or less the process kind of stays the same. You start with a clear and written notice, you fill out some forms, you serve the documents, you attend the trial, and then you wait for judgment. So what I'm going to do is detail out a summary for you to follow when you're going through this process, but please remember that I am not an attorney. This is not legal advice. I didn't go to law school. The best thing you can do for your case is ask an attorney in your area for legal help, especially if you have any specific questions on your landlord-tenant rights. So an eviction notice is a form that is filled out by the landlord that details out the violation and whether or not the tenant can fix the issue. Now, the notice period depends on the reason for eviction, but this form is essential because without it, the tenant may very easily win the case. So the most common reason for an eviction is a failure to make a timely rent payment. So a landlord can evict a tenant for failing to pay the rent when it's due. In Alaska, rent is generally considered late a day past its due. However, there might be a grace period that allows them more time to pay the rent that's due if it is indicated within the lease or rental agreement. But before a landlord can start with the eviction process for not paying the rent, a landlord must provide the tenant a written eviction form, which is called a 7-day notice to quit. So this notice basically just informs the renters that they are required to move out of the property or pay the rent within 7 days in order to avoid eviction. If the tenants who are being evicted for failing to pay rent on time manage to pay all rental payments in full to the landlord before the 7 days are up, then the entire eviction process stops and they can continue staying within the rental premises. So a lease agreement can vary from tenant to tenant. Now, landlords and tenants are both required to uphold all terms of the lease agreement at all times. However, the landlord can evict a tenant for a lease violation. In this case, the landlord must provide the tenant with a 10-day notice to comply, which gives the tenant 10 days to fix the issue. Some of the more common lease violations include things like damage to the rental unit, smoking and non-smoking areas, health and safety violations, too many people living inside the rental unit, or housing a pet in a pet-free rental zone. And the landlord may continue filing for the eviction lawsuit if the tenant fails to resolve the issue and remains inside the rental unit after the given notice period. Now, if a tenant engages in illegal activity on the rental premises, then the landlord must give them a notice between 24 hours and 5 days to move out of the property. Usually, 24 hours is given to people that cause more than $400 worth of property damage. So this includes things like gambling, prostitution, or the involvement in the creation, distribution, or consumption of a controlled substance. And should the tenant remain on the rental premise after the notice period ends, then the landlord can continue filing for an eviction case. Utilities include things like electric, gas, water, etc., and tenants are usually required to pay for whichever utilities are stated within the rental agreement. Now, should the tenant fail to pay them and get those utilities disconnected from the rental unit, then the landlord can evict them for that as well. In this case, landlords must give their tenant a written eviction notice of at least 5 days. However, if the tenant was able to pay all due amounts for the utilities and services restored within 3 days of receiving the notice, then they may stay on the rental premises. So this is a weird one, but repairs, inspections, and shows of the unit are reasonable causes for the landlord to enter the rental unit. Now, of course, they have to ask for permission first, but if a tenant refuses to allow the landlord access for any sort of petty reason, then the landlord can give the tenant what's known as a written notice to quit that gives them 10 days to move out of the property. This notice just informs the tenant that they have 10 days to move out or else an eviction lawsuit will be filed against them. So an Alaska eviction process does not allow a landlord to evict a tenant without good cause. So basically, as long as you don't violate any of the rules, you can stay until your rental period ends. However, tenants can be evicted if they stay in a rental property even a day after the lease ends and they have not arranged for a renewal. Now, this type of eviction notice usually only applies if the landlord wants to end the tenant's lease, and the required notice time given to a tenant really just depends on their tenancy type. So if the tenancy type is monthly, the landlord may issue a 30-day notice to quit, but if it's weekly, it might be a 14-day notice to quit. Now, should the tenant remain in the rental premises even after the notice period ends, then yes, the landlord may continue to file for eviction proceedings in order to evict the tenant from the property. So before filing an eviction with the court, you need to issue what's known as a notice to comply. So if you check out our website, you can download either a free PDF or Word template from there, or you can create your own using this step-by-step wizard that'll help guide you through the whole process. The benefit to that is that it's going to make sure you're submitting the legally correct notice. And while there is a small fee that you'll have to pay at the end, I would say that is a small price to pay for peace of mind knowing that you did the entire process the legally correct way. Now, after the notice period has passed, the landlord may file a complaint. Successful evictions rely on correct filings, so the landlord must be sure that they filed all of the forms correctly. So step 1, you proceed to the justice court that the rental property belongs to. Step 2, you fill out the form. Step 3, you pay the filing cost. As far as timeline goes, it takes between 24 hours and 30 days before a landlord can file a complaint. This really just depends on the type of notice given to the tenant. So the summons and complaint must be served to the tenant, and the landlord must not serve this document themselves. And the document should contain certain information like the date and the time of the court trial. Now, Alaska allows a professional process server or a peace officer to serve the document, and it must be delivered at least 2 days before the eviction hearing is scheduled. So if you can't serve it, how do you serve your documents to a tenant? So the summons and its corresponding documents have to be served through one of the following methods. You can use a personal service in which the summons and complaint is served to the tenant in person. Now, if the tenant is unavailable and personal service cannot be conducted, you can use what's called a substituted service. So in this case, a copy of the summons and complaint may be left at the tenant's place of residence or rental unit with someone who lives with them. Now, if neither of these are available, you can use what's called a mailing service, and in this case, the server mails the documents via certified or registered mail and requests a return receipt. Now, the tenant has the option to file for a continuance that lasts no longer than 2 days. However, if the eviction involves a monetary dispute, such as money damages, then the tenant must file an answer within 20 days that shows that they disagree with the complaint. So as far as timeline for this part of the process goes, the summons and complaint must be served at least 2 days before the eviction hearing is scheduled. And as I said, cases that involve monetary damage could take up to 20 days to file an answer with the court. Now, if the tenant disagrees with the eviction request and they reply to the court, it's important that you keep extremely good records of everything so you can provide proof to your judge and, well, win the case. So how can you stay organized? Well, one way is you can keep a physical paper trail. But the problem with this is that it gets very hard to search through, especially if you're not organized. It takes up a lot of storage space and things could very easily get lost, damaged, or stolen. So the next alternative is to get a scanner and scan all your documents into your computer. You can find a ton of great scanners on Amazon for $200, $300, $400. And then once you've scanned them, you can back everything up. Store and back everything up using Dropbox or Google Drive, something that's easily usable and searchable. Alternatively, you can use what's known as a property management software. These will allow you to save everything from lease agreements, signed documents, or violations, emails, photos, and videos. Really anything you need that'll help you win this case, you can store in one convenient and easy to search place. Now, if the tenant doesn't pay rent and they dispute the claim, it's important that you show the judge the following. 1, show them your lease agreement. Show them the terms, when the rent is due, and any penalties that are included for not paying rent on time. And then show them the history of payments. Show them all the previous payments, how they were normally made, and what date they were normally paid on. If there are any payment returns, checks bounced, insufficient funds, chargebacks on cards, show them that as well. And then show them any bank fees that have been charged to you and any penalties you are now owed according to your lease agreement. And honestly, in my opinion, one of the more important ones, if you had any automated or manual payment reminders that you sent them, it's important to show this too. Because while it's not really needed, it's a good way to show that they were aware of the situation, they were given time to cure and make a payment, and they still did. This is why it's best to have everything in writing instead of relying on face-to-face meetings and phone calls. Now, if you're evicting your tenant for lease violations like unauthorized pets or property damages, there's a couple really good ways that you can get proof of this. The best way is if you have security cameras. I mean, if you have a surveillance system that can show them committing the crime or violating the lease, pretty safe to say that you'll win the dispute. But if you can't catch them in the act, the next best thing you could do is take out your phone and record a video of any damages or lease violations. And then while your phone's out, back that up with some pictures. And even if you do take the video, it's important to show the judge any pictures, and plus they're usually easier to see by email or when they're printed out. So a landlord has to provide a strong argument backed up by solid evidence against their tenant in order to win. And should the tenant fail to show up to the hearing, well, then the landlord wins by default. But either party may appeal the judgment within 30 days from the time the judgment of possession was issued by the court. Now, if the case involved unpaid finances or monetary damages, then a separate damages hearing is actually held after the eviction hearing. And should the tenant fail to file an answer, then the court may approve the landlord's monetary claim without needing a hearing at all. During the court hearing, the landlord has to support their claim and show evidence to the judge. This includes, but is not limited to, things like the following: a copy of the deed and the lease agreement, rent receipts, rent ledgers, bank statements, witness statements, or any photo and video documentation of the violations committed by the tenant. So at this point in the process, here's the timeline you're looking at. The eviction is scheduled for 15 days after the landlord has filed the complaint, and then each party has 30 days to file for an appeal for reconsideration after the judgment has been passed. Great, so you won the case. What do you do now? So once the landlord wins the case and provided the tenant does not file for an appeal or reconsideration, the court will issue what's called a writ of assistance upon the landlord's request. So we're talking about a lot of documents here. What's the difference? Well, the judgment of possession is a document that tells the tenant that they have to move out by a certain deadline, which is given by the court. So the final step in the eviction process is to move the tenant out of their housing on the property. Now, Alaska laws don't really dictate how long a tenant has to move out of the rental property. However, the court usually announces this information after the judgment for possession is given to the landlord, but nevertheless, they still have to pack their things up and leave. So as far as timeline goes for this section, as I said, the law doesn't really outline anything specific, but the writ of assistance may be issued within a few hours to a few days, while the move-out period can take a few days up to a few weeks. So here is from beginning to end what the eviction process in Alaska looks like, but to boil it all down, on average it takes between 1 and 2 months to complete the eviction process. Self-help evictions. Oh my god. Don't. So basically, in almost every state in the US, the landlord must never try to force a tenant to move out of the rental unit. This is categorized as a self-help eviction process. Tenant can only be removed from the rental unit after the landlord has successfully won the eviction lawsuit. And even then, the person authorized to remove the tenant is only the sheriff or the constable. Alaska law has actually made it illegal for a landlord to personally remove the tenant from the rental unit themselves. So what constitutes as a self-help eviction? Well, examples of self-help eviction include things like changing locks, taking away the tenant's belongings, removing the front door, or turning off important utilities like heat or electricity. And many states actually specify how much money a tenant can sue for, yes, sue for, if the landlord has tried to illegally evict the tenant through using some sort of self-help measure. And in some states, they also provide for the tenant court costs and attorney fees if the tenant successfully sues the landlord. And sometimes they give the tenant the right to stay within the rental unit. So no matter what you do not do it. So as far as Alaska goes, according to Alaska Civil Code, you may be liable for tenants' court costs and attorney fees. And like I said, the statute would also give the tenant the right to stay. As well, the tenant can sue you for actual damages, violations, and they can ask for an injunction prohibiting any further violation during court action. What did I just say? No. Like I said, a landlord can be sued for a forceful eviction of a tenant. So don't do it. Now, some of the other consequences can include being sued for 1.5 times worth of actual damages, as well as attorney fees. Yes, but it kinda depends on the reason. In cases involving non-payment of rent, the entire eviction process stops if the tenant pays all of the rent due in full. And the same goes for tenants being evicted because of a lease violation if they cure that violation within the required time frame. Evicting squatters is a whole other process. Now, I'll leave a couple articles down below in the description for you guys to check out, but if you want to learn more information, let us know in the comments and we'll do that in a future video. Thank you so much for watching. I hope this helps if this is a process that you're going through. Be sure to check out this playlist where I cover a bunch of other landlord-tenant laws that you should know. Subscribe if you haven't already, and I will see you in the next one.